Hi, this is Josh Blackman, and I'm the president of the Harlan Institute, and it's my honor to welcome you to the 2021 Virtual Supreme Court competition. This year, we are arguing the case of New York State Rifle and Pistol Club versus Bruin. We are in the semifinal round, and this is match number 10. Representing petitioners is Creekview High School in Texas with Isaac Yu and Brandon Fontaine. And representing the respondents from Frisco CTE Center in Texas, Adithi, Ram Prakash, and Katie Donser. And we are here today joined by myself, my colleagues, Ashley Wollaston and Rick Carrillo, and we'll be judging this match. No further questions. Petitioners, you have 10 minutes. Begin whenever you're ready.
May it please the court. My name is Isaac Yu.
And my name is Brandon Fontaine.
And we represent the petitioner, New York State Pistol and Rifle Association. Our argument consists of three main points. One, the existence of the special need requirement causes New York penal law to be unconstitutional, as it cannot be examined by any form of judicial scrutiny. Two, English common law tradition and American laws enacted in both the days of the founding fathers and the 19th century firmly established the right to bear arms in self-defense. And three, under a pre-ratification review, the home and hearth requirement of Heller is not constitutionally applied, as it does not employ a proper definition of self-defense.
To move on to our first point, the existence of the special need requirement in general causes New York penal law to be unconstitutional, as it cannot be examined by any form of judicial scrutiny or other tests.
But why is that the case, right? Why can't the standard be examined by some standard?
Your Honor, since this deals with an amendment, it cannot be examined under the rational basis test. In terms of strict scrutiny, it would not pass that test.
We'll get to scrutiny in a minute, but why is the good cause standard cannot be reviewed by any court? I think that isn't there. In other words, if you get your permit denied, can't you appeal that to a court, to a judge in the New York State court system?
Your Honor, although you can appeal the specific facts of the case, like the specific sort of denial, the test as written, or rather the law as written, cannot pass any sort of true legislative review.
But there is review. I'll make sure I understand. You said before that there's no review, but now you're saying that there is some review, but it's not the review you want.
Your Honor, it is not necessarily a review, rather a process that can be enacted depending on the facts of your case, like you mentioned, the appeals system. However, the forms of review, specifically that being those decided in US v. Mazzarella, the strict scrutiny, intermediate scrutiny, rational basis test, and just a more general sort of good cause, like you mentioned, just cannot justify the New York penal law in question as written.
Okay, you may proceed, Counselor.
Counselor, while we're on the subject, could you go ahead and talk about the Friedman test that you suggest instead of a strict scrutiny analysis or any of these other standards or reviews?
Well, Your Honor, the Friedman test sort of requires laws that deal with the Second Amendment to be analyzed under two types of scrutiny at once. In particular, this is intermediate and strict scrutiny. The reason why we proffer this test is it's a lot more restrictive and a lot more pinpointed as to what is legal and illegal in terms of owning a firearm and operating a firearm inside the home and outside the home.
Okay, I proceed.
So more specifically, to add on about the test proffered in Friedman, New York penal law in question would not satisfy intermediate scrutiny as established in Caroline v. Products Co. Laws that regulate a specific enumerated right need to be protected, and further elaborated on in Kilchalski v. the County of Westchester. The special need requirement was defined to include target practice, hunting, and self-defense. As it pertains to this case, our clients did offer self-defense as a reasoning behind why they required the use and ownership of a firearm. In this case, denying that request for self-defense goes against the principles established by the New York State courts, and therefore would not fall under intermediate scrutiny. For strict scrutiny,
let's just talk about scrutiny. Did Heller establish what level of scrutiny, and this is for Isaac, Did Heller establish what level of scrutiny is used for Second Amendment claims?
Well, Your Honor, I believe Heller established intermediate scrutiny as a standard.
Did Heller say intermediate scrutiny?
I'm not quite sure, Your Honor.
Or did Heller say heightened scrutiny?
I'm not quite. I'm not.
Okay, that's fine. Well, Heller said we follow heightened scrutiny, right? Which heightened doesn't mean strict or rational basis. Explain to me, why would the New York good cause standard fail under intermediate scrutiny? Let's start there.
Well, intermediate scrutiny needs to be in pursuance of a larger government interest and must be substantially related to that interest. Well, Your Honor, you could argue that this New York provision was in pursuance of regulating firearms, which is a legitimate government interest. However, we argue that despite being in pursuance of this legitimate government interest, it clearly violates against the Second Amendment, and we believe that by itself makes it not substantially related, Your Honor.
Okay, you may proceed.
Moving on to our second point, Your Honor, historical precedent regarding the right to bear arms clearly lies that the right to bear arms extends beyond the home, Your Honor. Looking back to English law as far as Alfred the Great, pre-Norman times, all freemen were armed, trained, and ready to fight to defend their local national communities, which included beyond their own property lines. And moving on to colonial founding era American law.
I'm gonna stop you there. What do you do about the Statute of Northampton, which prevented the carrying of arms?
Well, Your Honor, Statute of Northampton was enacted in a time of English history where it was common and rife with domestic insurrections and rebellions. So it was enacted in an effort to quash those rebellions rather than prevent free law-abiding citizens from defending themselves.
Sure, but what do you do about the fact that the state of North Carolina essentially mirrored that law and held that Northampton-style prohibition carry was just fine post Second Amendment ratification?
Well, Rogers v. Grewal says that from the beginning, the scope of the National Statute of Northampton was unclear, that one clause could be read as a sweeping ban, or while the other is just but in reality, the enforcement of the law was a far more limited restriction.
But didn't Rogers versus Graywall uphold New Jersey's carry restrictions?
Well, Your Honor, we still hold that the Statute of Northampton's provisions has no real bearing on today's case.
Then what's the best piece of historical evidence that you guys have?
The overwhelming amount of founding era American law.
Give me one. What's your best one? And this is for Brandon. Give me your best piece of historical evidence.
Your Honor, the pieces of evidence are numerous, but for example, William Blackstone's commentaries on the laws of England do boil down personal rights, including self-defense.
Okay, all right, you may proceed.
So as a result of this English law, common law tradition, no American law during the colonial founding period outlawed the wielding of firearms. In fact, many of the founding fathers themselves actively defended the right to bear arms outside the home, and many of them did bear arms outside the home, such as Thomas Jefferson carried Turkish pistols with him in his carriage, and there are numerous other examples of such instances. And it is abundantly apparent that the founders continued this tradition of English right to bear arms, which would carry through our modern day interpretation of the Second Amendment.
Moving on to our third and final point, the home and hearth requirement of Heller is not constitutionally applied, does not employ a proper definition of self-defense, and does create a slippery slope fallacy.
Are you criticizing Heller? I'm not sure what you took home and hearth. That's from Heller, right?
Yes, Your Honor.
So are you criticizing Heller? I'm not sure exactly what you just said.
Your Honor, it's not particularly the final decision in Heller. It's rather the overreach of the court declaring a home and hearth requirement on the ownership of guns. This would not apply to all people. Take, for example, the homeless population. They are, by definition, don't have a home or a hearth that they belong to.
Just to be clear, though, you're saying that the Supreme Court was wrong to make the home and hearth analogy in Heller?
Your Honor, the Supreme Court was not necessarily wrong, but for the facts of the case, it was an overreach. However, because of stare decisis, it does need to be debated whether or not that should in fact apply specifically in today's case.
Okay, you have about 30 seconds left, counsel, if you want to wrap up your opening.
Your Honor, based off of the English common law, American foundational documents, the home and hearth requirement in Heller being an overreach of the courts at that time and not being able to be applied in today's case. And of course, how we began our argument with the fact that the special need requirement being an overreach and something that would not satisfy any burdens, we ask that you find in favor of the plaintiff. Thank you.
Thank you so much. Okay, could the respondents please come on camera? And Katie, just keep your camera off for now. I'm sorry. And we'll do the best we can. All right, you have 15 minutes. I mean, whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Aditi Ramprakash, and this is my co-counsel, Katie Donster. And together we represent the respondent in today's case, Kevin P. Bruin. Now, in September of 2014, Robert Nash and Brenda Coach both applied for a concealed carry license. However, both licenses were denied, and this is because the government of New York concluded that both Nash nor Coach did not demonstrate a special need, and therefore thus lacked a proper cause concealed carry license. Now, the question presented to you today is that does the Second Amendment allow the government to prohibit law-abiding citizens from carrying handguns outside the home for self-defense? And we're arguing today that the Second Amendment does not prohibit states from denying a license to carry a handgun outside the home. This court should uphold the decisions made by the United States District Court of the Northern District of New York, and we ask that the court maintain the ruling and maintain the precedent of common law.
The Second Amendment has been held by this court with the contention that a well-regulated militia be maintained in the sense of that thorough regulation on behalf of each state with the sale and licensing of firearms with federal regulation be maintained through precedents such as District of Columbia v. Heller. This court has set the precedent based on the Second and 10th Amendments that states have the discretion to regulate the licensing of gun use and licensing. We assert that the Second Amendment is dynamic and changes based on the needs of the time, as demonstrated in New York's strict law preventing the licensing of firearm carry.
Counselor, Ms. Donster, if I could just interrupt you just for a minute. So you say that the meaning of the Second Amendment should evolve with time. Is that consistent with how Heller approached the Second Amendment?
Based on the precedent of Heller, we are stating that there's a separate argument. We are stating that the state and federal authorities are allowed to maintain regulation, and they're allowed to do that with the evolving needs of the time.
But is that what Heller said, though? Wasn't Heller more of an originalist decision that was looking at what the text meant in the 1790s?
I'm so sorry. Could you please rephrase that? I'm not sure I quite understand your question.
Heller was focused on the original meaning of the Second Amendment, right? How the phrase would have been understood in the 1790s. What you're describing is more of a living constitutional model where we sort of have an evolving standard of decency. Do you think the Supreme Court and Heller followed the evolving standard model or an originalist model?
Your Honor, we believe it follows a more originalist model, but in the sense that unreasonable harm is not caused in any way. In the way, because both weapons and violence have evolved, we are arguing that the protections against this should still be applied no matter what that looks like.
Let me ask Ms. Ramprakash a question if I can for a moment. Does Heller allow us to sort of balance these interests where you have a right, but people are dying? Does Heller allow us to do the sort of cost-benefit analysis that you're suggesting?
Yes, I do believe it does. With the idea of the well-regulated militia being established in Heller, I do believe that it does have that cost-benefit standard that you were talking about, Chief Justice.
Well, what's level of scrutiny adopted in Heller? Maybe help us there.
It I believe it's the intermediate scrutiny, Your Honor.
Did Heller say intermediate?
I'm not quite sure on that, Your Honor.
I think we did this before. It said heightened scrutiny. But go on. Do you think your law would survive intermediate scrutiny?
Yes, I do, Your Honor.
Maybe walk us through that, please.
To pass intermediate scrutiny, law must further an important governmental interest. The important governmental interest here today is that New York first intended to base their firearm laws on the basis that a well-regulated militia be maintained by people capable of bearing arms. So, Your Honor, were you about to talk? Oh, sorry. And so people demonstrate need in terms of special self-defense. That also means that translates into people that are capable of bearing these arms, which I believe passes the intermediate scrutiny basis, Your Honor.
I think I'm inclined to agree with you that perhaps if we apply intermediate scrutiny, which is certainly a lower bar than strict scrutiny, that you win in this case. My issue is how we decide whether to even apply intermediate scrutiny, because I'm rather convinced by the other side, I think, that this infringes on the core of the Second Amendment, which is self-defense in general, whether that be in the home or outside the home. Is there a Second Amendment right to self-defense on the street outside the home, counsel?
Yes, I do. And the law that the New York government cites does not prevent civilians from receiving a license, a concealed carry license. Civilians just have to demonstrate a special need for self-defense, considering their environment, their neighborhoods, something to
Sure,
demonstrate.
but and this is for Ms. Stoncer, but could you see that the special need requirement is somewhat counterintuitive, or maybe not counterintuitive is the word, but if we're talking about self-defense, oftentimes when one is walking to a store or on their way somewhere, they won't know when something is going to happen to them. You don't know when bad things are going to happen to you, else you probably wouldn't be at that place at that time. So, do you see the issue I'm having with the law here, counsel?
Yes, Your Honor, I do understand that. However, we are arguing that for certain people to be in possession of these firearms without previously established need, I do understand that there's a certain unpredictability sort of element to danger and being in harm's way. However, I believe almost anybody can walk out onto the street and anything could happen to you at any minute. That is unpredictable. But what we can do is, in order to sort of regulate that, is to make sure firearms aren't getting into the hands of the wrong people, Your Honor.
Well, why wouldn't background checks be sufficient, right? I think 42 or 43 states will give you a concealed carry license so long as you pass a background check. Why is that not enough? Why do you need this good cost standard to keep guns out of bad people's hands?
Your Honor, we believe that we need, and I believe that in particular, the proper cause basis allows us to have a more conservative approach to allowing people to defend themselves from what is necessary, such as establishing the need that you require a firearm for self-defense or occupational purposes. It allows you to have a firearm with a purpose. Not all people who apply for concealed carry necessarily require these firearms.
Right, but the plaintiffs in this case say that they live in they fear crime, there's robberies, there's break-ins. Why is that not enough?
Your Honor, I would like to pass this question to my co-counsel, please, for just one moment. I'm so sorry.
That's okay. Yes.
Your Honor, could you repeat the question?
In this case, the petitioners say they need guns because there have been robberies and break-ins in their neighborhood, and they want to have self-defense. Why is that not enough?
Well, Your Honor, we're upholding the standard of a proper cause to further promote a sense of peace and domestic welfare. We believe we are trying to prevent further violence, that giving someone to defend themselves against robberies, shooting, if they use their own weapons in that violence and thing, we believe that it's going to add to the violence, add to the thing, and unnecessary harm could be brought to the people or the surrounding communities, Your Honor.
Okay, all right, you may proceed. Is Ms. Donster still here or? Hope
Yes, Your Honor, I'm still here.
That's okay. Okay, I just want to make sure you're still here 'cause we couldn't see. You may proceed, Counselor.
The original intent for the Second Amendment, Your Honors, was it to be used by means of to which to allow a young country to protect itself from external threats. We were thinking about this when we were, as example of the Revolutionary War, where on behalf of the framers intent in keeping a well-regulated militia. Over time, the concept and standing with this amendment, such as arms and other precedents, have been established. Now, this court has defined the term arms as all firearms and all instruments that constitute.
Counsel, allow me to interrupt. Let's say we were inclined to take an originalist approach here, meaning we'd be looking at history and tradition. The other side has, I think, a very strong argument that the original framers and the founders had a very expansive idea of gun rights. I mean, could you point to any examples that are contrary to that in the historical sense?
If we think about the words of William Blackstone, a deadly force is only permissible when certain immediate suffering would be the consequence of waiting for assistance. So,
sure, but other than Blackstone's commentaries, which are like just a book on it, do you have any laws in the United States that were enacted by any of the several states that perhaps exhibit like the good gun regulation that you would have us uphold here?
I don't believe I do, Your Honors.
Okay, you can go proceed.
Furthermore, the militia has delegated its power in the sense that discipline prescribed by the needs of the time. Congress maintains its power to organize militias as seen in this case today, but the power that this court holds to keep consistency, defining the discipline needed to regulate firearm control as the concept evolves from past times to today.
Lastly, we will be moving on to founders' intent. So we would like to discuss how the founders' intent at the time was to prevent the need for a standing army in a weak and small nation. This was done for the purposes of specifically defense against tyrannical powers or potentially tyrannical powers of the time. However, the United States now has readily available armed forces and police forces to protect the country from external and internal threats and other bureaucratic agencies that promote domestic welfare. The respondent, we uphold the standard of a proper cause to further promote this peace and domestic welfare in accordance.
Well, let me ask you a question, right?
Yes, sir.
What exactly is proper cause? Let's say there's a woman who fears her spouse is abusive and he may harm her one day. Is that enough?
We are arguing that proper cause is established. It's strictly case by case. So taking your example, Your Honor, I would say that is proper cause, need for self-defense.
Okay, so let's try another one. Let's say that, a woman and a man are married and the husband's never made any threats, but, she drinks sometimes and, she's worried, but never threatened any violence. Is that enough?
I believe that would not be enough, Your Honor, as long as there's no sense of danger, real danger that can be established.
Let me try another one. Let's say that a woman has a neighbor across the street who always kind of just looks at her and she gets this creepy feeling, but he's never said anything to her, but she gets this creepy feeling whenever he walks on the block. Is that gonna be enough?
That would not be enough for proper cause, Your Honor.
I mean, look, in all the examples I gave you, there could be violence against these people, harm. The good cause standard will allow a lot of bad things to happen, wouldn't it?
Yes, Your Honor. However, there are other means of self-defense, and there are also
Well, what are these other means?
established bureaucratic forces.
Pepper spray? I mean, what are we talking about? Is that going to be enough to
We-
ward off an assailant?
Yes, Your Honor. We have pepper spray. That does work. We have physical altercations. We have police forces that can be called to come in and protect. That's what they're there for.
Okay. All right, Counsel, you had a minute left. You may proceed.
Yes, Your
Counsel,
Honor.
is it the position of the respondent that the New York statute is not too strict and is actually required to meet the needs of the citizens?
Yes, it is, Your Honor.
And do you have any statistics to back this up? Of why New York needs it, but then with the majority of other states who don't have it? Like what is the big gap?
I don't believe we have any statistics, Your Honor, but we do believe that as the court defined proper cause to require applicants to show a special need to defend themselves, we believe that it's an attempt to reduce violence within New York, Your Honor.
Okay, and I think you're just about time. Thank you so much. We now have 5 minutes of time for the petitioner. Please come back on camera. All right, whenever you're ready, Counselor.
Your Honor, may we have a brief moment just to collect our thoughts?
You have a minute. All right, Counselor, you ready?
Yes, Your Honor.
Okay, we proceed.
May it please the court. Regardless of the evolution of weaponry, the right to self-defense is something that, based on foundational documents, is meant to be protected by all legislative bodies. Denying the petitioners that right when they requested a firearm did not uphold that historical interpretation. The respondent's contention that the special need requirement is meant to keep guns out of bad people's hands still does not mean the right to arms should be denied to all people unless an exception that is yet to be defined by the New York State courts is present.
By upholding New York's penal code law, such a strict restriction on Second Amendment laws, it leaves a lot of marginalized groups, such as the homeless, as mentioned previously, and other groups such as women, the Jewish, and LGBTQ community, which have been the targets of disproportionate levels of violent crime, vulnerable, and unable to properly defend themselves, Your Honor. Especially as being part of the group, simply being part of one of these groups does not qualify under the special needs requirement.
Additionally, the respondents also contended that this law prevents potential unnecessary harm from occurring, but that creates a slippery slope of where the line is drawn. Harm being necessary or unnecessary is something that cannot be defined.
So, Counselor, let me ask you a question. How many dead bodies would it take for you to agree with the other side?
Your Honor, it is not a metric of the volume of dead bodies, rather of allowing people to have weaponry to defend themselves so they can't become part of that.
Right, but you're talking about one half of the equation. I get it, self-defense, but also some of these guns might be used to harm others. So how many dead bodies will it take from concealed carry permit holders for you to revisit your position?
Well, Your Honor, it is not necessarily an issue of dead bodies or any sort of statistic of that matter. People being able to defend themselves would not only help lower that metric, that statistic of dead people, but as it pertains to our side of the argument, the amount of people who die is not necessarily related to the New York law in question. We are not arguing for the rights of guns to be given to all people, rather for the New York State Court to remove the unnecessarily restrictive requirement of special need that helped deny our clients' wishes for firearms.
Okay, thank you.
Harm being necessary or unnecessary is not something that can be defined without specific specific articulable facts of a case, and making a ruling that is not dependent on the facts of every single case would create a slippery slope of interpretation for future decisions in future cases.
Finally, Your Honor, opposing counsel does state that the right to bear arms is based on the furtherance of a greater common defense in the form of militia. However, Heller establishes that the pre-factory militia clause does not alter the purview of the operative clause, and was drawn up in order to prevent Congress from abridging the individual's right to bear arms. And it's for these reasons we pray that the court rules in favor of the petitioners. Thank you, Your Honor.
Okay, excellent. Thank you so much, Counselor. Let me stop the clock. All right, everyone come back on screen. You too, Katie. Thank you so much. That was, you guys have fun? You enjoy that? Yeah, I know it's really tough sitting here getting like, you see a boxer getting bloodied one after the other, ask you questions like how many dead bodies will it take? And you know what? You kept your cool, right? You kept your cool. You didn't lose your composure. You didn't lose your stability. You were smooth. You answered all of our questions. When you didn't know, you said, I don't know. And you're allowed to do that, right? If you don't know the answer, don't make it up. That's bad. If you make it up, you kill your credibility. So if you don't know, say, I don't know. And if you give a wrong answer and the judge is kind of nudging you, heightened scrutiny, right? Just take the hint and say, okay, and roll with it, right? Don't resist it. I think you're all very smooth. You're not going to be able to answer all the questions, right? The judges in these competitions will try to push you as hard as they can to get you out of your comfort zone. And they're not going to let you become comfortable. So always remember, they're going to try and nudge you to do better. But I think all of you did a really solid job. I know you're all in high school, freshmen, sophomore, junior, seniors, different years, but you're performing years ahead of your ability. You're performing at the level of law students. You can walk into the first year of law school tomorrow and participate. And you should be very proud of that. I think you'll have great, bright futures ahead of you. Whether you do law or something else, we'll be all better off for it, having your sort of insight and your passion. So thank you all so much. And I'm really, really fortunate that you're here today. So thank you. My colleagues Ashley and Reed are current law students. They're sort of closer to this than I am. And maybe they have some comments and feedback for you all.
Sure. Yeah, I think y'all did really well. I like that y'all were composed when you talk and you took time to articulate your arguments, because I think it just came out well. The only suggestion I would have is in the future, the petitioners here have like a unique side where they get the other 5 minutes for rebuttal. But I mean, you're not always going to be petitioner or respondent. It's going to change up. So try to get ahead of the arguments of the other side and say, like, when you're saying, the petitioners are going to say, well, in the respondent's brief, they said this. However, I think this. So just get ahead on either side is what I would suggest.
Yeah, I think everyone did a good job. Everyone was very clear. I can't believe you guys are in high school. A few things I will say, just with more specifically, when judges push you on stuff, you don't necessarily have to concede it. I think it's frankly a good thing to stick to your guns. How many bodies would you be comfortable with? Well, that it doesn't matter. That's not what this is about, right? And I thought that was a particularly good thing there. I think everyone did a very good job with giving deference to the court. It's your honor. Anytime you address the court, I thought that was very good. One thing that I think everyone could improve on a little bit is listening to the other side. I, in moot court rounds, keep a notebook or notepad on me, a legal pad on me, to write down what was mentioned on the other side. If there's a question that the other side didn't particularly address well enough, come back and say when your time is when you're back up, Your Honor, and to address the question you asked about X, Y, and Z, here's my answer, and here's why my answer is way better than the other guys. So other than that, though, great job, guys.
Yeah. Do you have questions for us? I know Brandon and Isaac from some years ago. Anything that you guys want to ask us, anything in your mind about law school or whatever else you're thinking about?
Not particularly.
No?
We don't have any questions either, but this was a very good round to get to have.
Great experience. Thank you.
That. Well, I'm grateful for you all. If you have any questions, you know how to reach me. But I wish you the best of luck. And if I don't see you again, I'm sure you'll do great things. But always keep working hard, because you have such talent, and I'm so thrilled to see what you guys can accomplish.
Thank you so much.
Thank you so much. Have a wonderful day. If the students can sign off, we'll talk to the judges for a bit, and then we'll get back.
Thank you.
Thank
Goodbye.
you.
Thank you. Okay, let me turn off the recording.